Hello, everyone. I just wanted to come today to go over the new vacant land listing agreement effective November 2024. So this is the new land agreement. A couple things have changed, not a lot. They just updated it a little bit to kind of mimic the new listing agreement for residential. Okay. So again, we're going to go step by step. The exclusive right of listing agreement is between seller, right? So you're going to put the seller's names in here, whether that's an LLC or there's 3 sellers or 4 sellers or 5 sellers, and brokerage. Here you're going to put La Rosa Realty if you are with La Rosa Realty. Obviously, if you're with another company, you're going to put another company, but this is for La Rosa Realty LLC as your broker, unless you're watching this and you are with another entity like La Rosa Realty Kissimmee or La Rosa Realty Prestige or whatever the brokerage name is, okay? You're not putting your name in here. You're putting the broker's name in here. Remember, this contract is between the broker and the seller, not you and the seller. You're just a representative of the broker. All right, so number 4, authority to sell property. Seller gives broker the exclusive right to sell the real property and personal property, collectively property described below at the price and terms described, beginning when? When does this contract begin? When are you listing this property? Okay. And terminating at 11:59 p.m. on what date? Now, land is a little hard to sell, so I would at least minimum put a year because land is a little harder to sell than a residential property. So at least give yourself a year as a termination, so that way you have time to sell this land, okay? Upon full execution of this contract for sale and purchase of the property, all rights and obligations of this agreement will automatically extend through the date of the actual closing of the sales contract. So what does this mean? This means that even if it ends on 1/1/2025, but you went under contract on 12/31/2024 and it expires the next day, this contract is still valid through the closing of the sales contract. Okay, so you're still protected even though it expires the next day after you went under contract. Seller and broker acknowledge that this agreement does not guarantee a sale. This property will be offered to any person without regard of race, color, religion, sex, handicap, familial status, national origin, or any other factor protected by federal, state, or local law. Seller certifies and represents that he or she is legally entitled to convey the property and all improvements. This is just saying, right, we can't discriminate. And also that they have to give a clean title, basically. Okay, so that's what that means, that it should be a clean title or marketable title, what they call marketable title. All right, description of property, street address. Obviously, you're going to put the address here. If it doesn't have a physical address, it just has a plot number or just a street number. Whatever it is that shows up on the tax records is what you're going to put here. Legal description, the same thing. Whatever appears in tax records, that's what you're going to put as the legal description. Personal property, including storage sheds, electrical, including pedestal, plumbing, septic systems, water tanks, pumps, solar systems, panels, irrigation systems, gates, domestic water systems, gate openers and controls, fencing, timers, mailbox, You get what I mean. Utility meters, everything, and lighting would be entered here if they are taking any of this, okay? So personal property is exactly that. Personal property, not included in the sale of the land. You would have to put here, okay? If they're keeping it. All right, so now you're going to go to occupancy. Occupancy is the property or not currently occupied by a tenant, or if occupied, the lease terms expires. Now you would think, okay, well, this is a piece of land. How is it occupied? It could be occupied by someone leasing it for agricultural. It could be somebody leasing it for a farm, to have their animals on there. It could be rented or occupied by a tenant, even though it's just a piece of land. Maybe somebody just has a trailer and they're just renting the land to put their trailer on. So you have to put in there if it is or it's not currently occupied by a tenant. Price and terms. The property is offered for sale on the following terms or on other terms acceptable to seller. So what price are you listing it at? Would be here, right? This is where you would put the price. I'm just going to highlight it if it'll let me highlight it. Nope, it's not letting me. All right, so right here on number 25 would be the price. Number 26B, financing terms. Most land in the state of Florida are cash only, unless they're, some sort of huge piece of land that it's commercial and now you can get some sort of financing. But most of the time it's cash. So you have to find that out from a lender or someone who can tell you whether that land can be financed or not. But otherwise, it would be cash. Seller financing. There are situations where the seller will finance the land. So do seller financing. They'll take on the mortgage of the new buyer and come up with an agreement where they're going to make payments to the seller directly. So this could happen, seller financing, if the seller wants that. Okay, and then you would have to put in there will hold purchase money mortgage in the amount of. So how much is it? I'm assuming it would be the purchase price, but this is the amount of the mortgage unless they're giving a down payment, okay? With the following terms here, you would write the terms of whatever that seller financing is willing to accept. Assumption of existing mortgage. So most land do not have a mortgage, but if it happens to have a mortgage, you're going to do assumption of existing mortgage. Buyer may assume the existing mortgage. This does not happen very often, but there are situations where that might happen. But again, you would just read that and fill out that if that is the case. Number 36, C, seller expenses. Seller will pay mortgage discount, other closing costs or concessions not to exceed X amount. Before it used to be a percentage. Now it's an amount. So basically, what that is, if the seller is willing to give any credit or some sort of concession for the buyer to help with their closing costs, like let's say they're paying for the title or they're paying for some sort of credit, some sort of concession to help with the cost of the or the closing cost of the actual land. Okay. All right, so broker obligations. Broker agrees to make diligent and continued efforts to sell the property until the sales contract is pending on the property. Broker's office policy is to cooperate with all other brokers except when not in the seller's best interest. So we are cooperating with other brokers except when it is not in seller's best interest, okay? Remember, you represent the seller. So if it's not in the seller's best interest, you cannot do it. Multiple listing service. Placing the property in a multiple listing service like the MLS is beneficial to seller because the property will be exposed to a large number of potential buyers. As an MLS participant, broker is obligated to timely deliver this listing to the MLS. The listing will be promptly published in the MLS unless seller directs otherwise in writing. So if you list it today, December 3rd, 2024, and it says that you're listing it today, you have 24 hours to put it on the MLS unless the seller authorizes broker in writing that they wish to list it January 1st, for example, okay? Seller authorizes broker to report to the MLS this listing information and price, terms, and financing information on any resulting sale or use of by authorized board association members and MLS participants and subscribers unless seller directs broker otherwise in writing. Okay, so it's just letting the seller know that we are going to put it on the MLS and we are going to market the property. Broker authority. Seller authorizes broker. Seller authorizes broker to advertise the property as broker deems advisable, including advertising the property on the internet unless limited in 6A right here, or 6AI below. So seller opts out. Check 1 if applicable. Display the property on the internet except the street address. That's one option that they have. The other option is seller does not authorize broker to display the property on the internet. Seller understands and acknowledges that if the seller selects this option, consumers who search for listings on the internet will not see information about the property in response to their search. And then they would have to initial here. Now, they only initial in these two spots, guys, if they chose this one, number 51, or they chose number 52. If they didn't choose any of these two, they do not have to initial, okay? I see a lot of that happening. So the only time that maybe a seller will not authorize the broker to display the property on the internet is if maybe they're an FBI agent or a government official or a police officer or someone they're trying to protect their identity. Those are all reasons why they would not want that. Other than that, we do need to obviously put it on the internet in order to market the property. Place appropriate transaction signs on the property, including for sale signs and sold signs. One seller signs a sales contract on the seller's name in connection with marketing or advertising the property. These are obligations, what they're basically telling us we can do. Obtain information relating to the present mortgage on the property. Obviously, if there's a mortgage, we need to know what the payoff is. Provide objective comparative market analysis information to potential buyers. Check if applicable. Use a lockbox system and a gate code to show access to the property. Obviously, it is a piece of land. So unless it has a gate that is surrounding the piece of land and you need keys to open up that gate or a remote to open up that gate, obviously you won't need a lockbox. But if there is a gate, maybe you might need a lockbox. So it's totally up to the situation with the land. Persons working through broker. Okay, so seller agrees that the lockbox or gates for the gate is for seller's benefit and releases broker persons working through the broker and brokers local realtor broker association from all liability and responsibility in connection with any damage or loss that occurs. Okay, so this is basically just saying, hey, Mr. Seller, if anything happens, while we're promoting your property, we are not responsible for it. Okay. All right, so here, withhold verbal offers, withhold all offers when seller accepts sales contract. Again, you would check if they want you to withhold verbal offers, or if they want you to give them verbal offers, then obviously you won't check that. Withhold all offers when seller accepts sales a contract. Again, this is, up to the seller. Do they want to, once they get an offer, they don't want to hear about any other offers, or once they accept an offer, they still want to see what other offers come in. That's totally up to the seller what they want. And so that's a discussion you have to have with them and see what they want. All right, virtual office websites. Some real estate brokerages offer real estate brokerage services online. These websites are referred to virtual office websites. An automated estimate of market value or reviews and comments about this property may be displayed in conjunction with a property on some of the VOWs, which are the virtual office websites. Anyone who registers on a virtual office website may gain access to such automated valuations or comments and reviews about the property displayed on the virtual office website, unless limited below. So again, this is just giving us permission to put in the MLS whether we want to market it to virtual office websites. So websites that are maybe belonging to another brokerage so that they can upload it through the feed, okay? Seller does not authorize an automated estimate of the market value of the listing or hyperlink to such estimate to be displayed in immediate conjunction with the listing of this property. So if the seller does not want any of this, you would check those two boxes. Again, make sure you go over it with them. Seller does not authorize third parties to write comments or reviews on this listing. If you check these, this is a option on the MLS that you have to check off whether you want to display it in the virtual office websites or not. Okay, so make sure you just double check that with the seller and see what he wants. All right, seller obligations and representations and a consideration of broker's obligations. Seller agrees to cooperate with the broker in carrying out the purpose of this agreement, including referring immediately to broker all inquiries regarding the property transfer, whether by purchase or by other means of transfer. Provide broker accurate information about the property of which seller may be aware, including but not limited to utility, availability, presence of or access of water supply, sewer, or septic system, problems with drainage. Basically, I'm not going to read the whole thing, but basically this is just giving you the seller obligations and the representations of what's going on with the property. Basically, it's giving you the obligation that if the seller decides to transfer that property to someone else, like quit claim deeded, or transfer it to a son or a daughter, or any type of changes in title, the seller is obligated to inform the broker of any changes, okay? in title or anything of that nature. Obviously, provide accurate information, whether the sewer, if it's wetlands, is it used for commercial or industrial? Is there any nuisances, any noise, odor, smoke? So just these are things that they need to disclose, okay? Provide broker access to the property and make the property available for the broker to show during reasonable times. Inform broker before leasing, mortgaging, or other encumbering the property. Again, if they decide to refinance it, right? They told you the mortgage was pay off on the mortgage, or maybe they didn't have a mortgage. And now all of a sudden they decide that they're going to either lease the land or mortgage it out, or anything else of that nature that's going to create an encumbrance on the property, some sort of hold on the property or lien, they need to notify the broker. Indemnity broker and hold broker harmless from losses, damages, cost, and expenses of any nature, including attorney fees. Again, this is just read all this very carefully. If the use of the lockbox or gate code, the existence of undisclosed material facts about the property, it's just basically telling them that we are not going to be responsible or held liable for their misrepresentation, okay? Perform any act reasonably necessary to comply with FIRPTA, section 1445 of the Internal Revenue Code. So again, that's just if the buyer or the seller is a FIRPTA or has to comply with FIRPTA, that they need that to do that. Make all legally required disclosures, including all facts that materially affect the property, obviously. And again, just read all this. And if there's anything that is not on here that they want to disclose, they would disclose it here. Seller will immediately inform broker of any material facts that arise after signing this agreement. Again, anything that happens to the land, any changes in anything, the seller will immediately inform the broker he is in violation of this contract. And by the way, guys, before I continue, I am not an attorney. I am not making any legal representations here. This is just going over how to fill out this contract. If there's any questions with your buyer or your seller regarding this contract, please recommend that they consult an attorney. Remember, you are also not an attorney, and neither am I. I'm just going through the contract on how to fill it out. All right, seller represents that seller is not aware of any notice of default recorded against the property, any delinquent amounts due under the loan secured by or other obligation affecting the property. Again, just making sure that they are disclosing everything regarding the land, okay? All right, let's get to the good stuff. Compensation. So compensation, seller will compensate broker as specified below for procuring a buyer who is ready, willing, and able to purchase the property and any interest in the property on the terms of this agreement or any other terms acceptable. Seller will pay broker as follows. So here you're always going to put what you're charging in full. If you are going to cooperate, if the brokerage is going to cooperate with any type of compensation, remember, compensation is negotiable. Just have to say that. Compensation is negotiable. So whatever the seller is willing to compensate the broker to sell and find a buyer for their land, for their property, basically they're going to give you what percentage of that they're willing to pay. Totally negotiable. I'm not going to give them out. You just put the total amount, okay? Of the total purchase price. So it's a percentage of the total purchase price plus if you have any type of bonus that you're going to ask for, if they need to pay you a transaction fee or any other fee, anything of that nature, you would add on here, right? No later than the date of closing specified in the sales contract. However, closing is not a prerequisite for broker's fee being earned. Please read this. Closing is not a prerequisite for broker's fee being earned. Just keep that in the back of your head, okay? They can still close on this property without paying you your compensation or earning that compensation, okay? So total compensation on number 113A. Now, on 116B and C, I see a lot of agents don't fill this in, and I don't understand why. Because if for some reason the seller in the middle of this contract decides, I think I'm going to go ahead and just lease the property. I'm going to do an option, like a lease with option to buy. right? Why would you not want to get paid if he decides to change or she decides to change their mind and decide that they want to option the property versus selling the property? In either case, you're representing them. So I would put a fee in all of these, because if they decide to do something like that, then you want a compensation put here for helping them with that option. Okay. If they decide to lease the property instead of selling it in the middle, they said, you know what, Teresa, I couldn't sell the land, or, we couldn't find a buyer. I'm just going to lease it while I find a buyer. Okay. Well, I want to get paid because I've been representing you this whole time. So I want to get paid if you decide to lease that property. So I normally put a percentage here, whatever that percentage is. I usually put a percentage here, because if that person changes their mind about selling and they decide to do one of these two options, I'm still getting paid, or the broker is getting paid, and then I'm getting paid. So I don't understand why people leave this blank. Okay. So just make sure that you put something in there, some sort of compensation. All right, broker fee is due in the following, and this is, again, if they decide to lease it, this is a percentage or an amount of the gross lease value as a leasing fee, right? Because you're going to probably still help them lease the property. And even if you don't help them and they find someone on their own, you're still got to get paid. You still have to get paid something. So make sure you put something here, guys. Broker's fee is due in the following circumstances: if any interest in the property is transferred, whether by sale, lease, exchange, governmental action, bankruptcy, or any other means of transfer, regardless of whether the buyer is secured by the seller. So even if the seller brings the buyer, broker, or any other person, if seller refuses or fails to sign an offer at the price and terms stated in this agreement, they default on an executed sales contract, or agrees with the buyer to cancel an executed sales contract if within protection period, guys, here, put a protection, 90 days, 60 days, 120 days, but put something in there, after termination date, which is the protection period. Seller transfers or contracts to transfer the property or any interest in the property to any prospects with whom seller, not just the broker, seller, broker, or any real estate licensee communicated regarding the property before termination date. However, no fee will be due to broker if the property is relisted after the termination date and sold through another broker. Okay, so what does this mean? It goes under contract, something happens, they decide to cancel the contract, they decide to, cancel it with the buyer, they decide to do something else, or they refuse to sign an offer at the price and terms stated in this agreement, or defaults on any executed sales contract, and all of a sudden they go back and they go under contract again during the protection period, you are still due your broker fee, your compensation, unless they take it off and now they relist it with another broker. Retained deposits. As consideration for broker services, broker is entitled to receive, again, you're going to have to put a percentage. It says 50% if left blank, of all deposits that seller retains as liquidated damage for a buyer's default in a transaction, not to exceed the paragraph 8E. So this retained deposits, it's called escrow. So if somebody put a $10,000 escrow and something happens and now the seller is due the escrow deposit because the buyer defaulted in some way or form, that $10,000, what percentage of that $10,000 does the broker want to charge? Because after all, they did do the work, they did bring the buyer, right? But the buyer fell through and now the seller wins the escrow. What percentage? Right? Commercial Real Estate Commission Lien Act. The Florida Commercial Real Estate Sales Commission Lien Act provides that when a broker has earned a commission by performing licensed services under a brokerage agreement with you, the broker may claim a lien against your net sales proceeds for the broker's commission. The broker's lien rights under the act cannot be waived before the commission is earned. Okay, so very, very important here with the new Commercial Real Estate Sales Commission Lien Act, okay? Compensation to other brokers. Notice to seller's broker, commissions are not set by law and are fully negotiable. Seller is advised and is aware of that, okay? Seller may, but is not required to compensate a buyer's broker upon closing. B, seller may choose to enter into a separate written agreement to pay buyer's broker or may approve broker to pay the buyer's broker. So it's just telling them what they can do. Seller now approves. Which one are they going to approve? This one, or this one? Are they going to approve that the seller authorizes the broker, so from the compensation that you're charging, to offer compensation to a buyer's broker in the amount of what percentage of the purchase price, or is it a flat fee? Because it doesn't have to be a percentage. It could just be a flat fee. This compensation will be set forth in a separate written agreement between the broker and the buyer's broker, okay, which is the compensation agreement from broker to buyer's broker, or seller's broker to buyer's broker, okay? B, or 2, seller authorizes broker to communicate seller's offer of compensation to buyer's broker in the amount of, so seller authorizes the broker to communicate seller's offer of compensation to buyer's broker in the amount of. So basically, it's just authorizing you, the seller's authorizing the broker to communicate with the buyer's agent or the buyer's broker what compensation is going to be given to them and if there's any other bonus. This compensation will be set forth in a separate written agreement between seller and buyer's broker. Okay? This one's so confusing, guys. But anyway, I'm just going to keep going because it's still confusing. That to me doesn't make any sense, but it's okay. I'm just going with the motions here. This compensation will be, who am I to fight with Florida realtors? All right, so this compensation will be set forth in a separate written agreement between the seller and buyer's broker. Again, the compensation agreement, okay? Or number 3, no compensation will be offered to buyer's broker. So the seller has the option, right, of which one to choose. With La Rosa Realty, we are not taking on any contracts that are not offering some sort of compensation to the buyer's broker because we are a cooperating brokerage. So if a seller says, oh, no, I don't want to pay a buyer's broker, then I guess you're not taking their listing, because as a brokerage, we are not agreeing not to take on no compensation for the buyer's broker. Okay. Conditional termination. At seller's request, broker may agree to conditionally terminate this agreement. If broker agrees to conditionally terminate to a conditional termination, seller must sign a withdrawal agreement, reimburse the broker for all direct expenses incurred in marketing the property, and pay a cancellation fee. So a cancellation fee if they decide to cancel this contract. Remember, guys, that as listing agents, we always have initial costs, whether that's photography, whether that's marketing, whether that's signs, whatever that is, those are things that we have expenses. I always put a cancellation fee. It's up to you and your brokerage whether they want to do that, but in my opinion, we should always use a cancellation fee. Plus applicable sales taxes. Broker may void the conditional termination and seller will pay the fee stated in paragraph 8A, less the cancellation fee if seller transfers or contracts to transfer the property and any interest in the property during the time period from the date of the conditional termination to the termination and protection period, if applicable. So read this very carefully. If you don't understand, please consult an attorney. Dispute resolution. This agreement will be construed under Florida law, all controversies, claims, and other matters. Remember, we are not signing any sort of arbitration, okay? So, and other matters in question between the parties arising and relating to this agreement or the breach thereof will be settled first by attempting mediation under the rules of the American Mediation Association or any other mediator agreed upon by the parties. If litigation arises out of this agreement, the prevailing party will be entitled to recover reasonable attorney fees and costs unless the parties agree that disputes will be settled by arbitration as follows. Arbitration. By initialing this, you are agreeing to possible arbitration. La Rosa Realty is not agreeing to go to arbitration. So these little spaces here for the seller and the broker will not need to be signed. So leave them blank. Your seller does not need to sign that because we are not going into arbitration. All right, so let's keep going here. Again, we're not doing arbitration. This is that whole paragraph. Miscellaneous. This agreement is binding on seller and broker's heirs, personal representatives, administrators, successors, and assigns. Broker may assign this agreement to another listing office. This agreement is in the entire agreement between seller and broker. No prior or present agreements or representations will be binding on seller or broker unless included in this agreement. Electronic signatures are acceptable and will be binding. Signatures, initials, and modifications communicated by facsimile will be considered as originals. The term buyer as listed in this agreement includes buyers, tenants, exchangers, optionees, and any other categories of potential or actual transferees. Obviously, any additional terms you're going to put in here, seller signatures, broker. Remember, with La Rosa Realty, as of today, we are requesting that no documents, no listing agreements be sent to the seller without us first reviewing your listing agreement and approving it and signing. So please do not sign where it says broker or authorized associate. It is only the broker who is signing, not the authorized associate. So please do not sign here because then I have to sign over you or try to find a space. Brokerage firm name. Obviously, you're going to put the brokerage firm name, the address of the brokerage. If you are in South Florida, remember it's always the celebration office, our corporate office. You're always going to want to put a date here as to when this document was delivered to or returned. The copy was returned back to, once it's executed, was returned back to the seller. And you're going to have to put by email, facsimile, mail, or personal delivery, whichever it is. You have to put a date here and how you delivered this completed signed document. Okay. And that is it for today, guys. If you have any questions, concerns, or comments, please leave them in the comments below. Don't forget to subscribe and like. And again, share with your fellow realtors so that they can get informed on how to fill out a vacant land listing agreement. Again, the new one effective right here, November 24th, right here on the bottom of the page is going to give you the revised version, revised 11/24. Okay. And again, this is being recorded on December 3rd, 2024. So if you're looking at this video 5 years from now, you might want to look at some other videos just to make sure that you are getting the right document. That's all I have to say for today. Thank you. Have a great day. And don't forget to share, like, and subscribe to my channel for further videos.